Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce laws, mediation practices, and regulatory requirements vary significantly by state and jurisdiction. We are not attorneys, and the historical trends and case studies discussed here should not be taken as instructions for your specific legal situation. Please conduct your own due diligence and consult with a licensed professional in your area before making any decisions regarding domestic relations or legal proceedings. For the last 50 years, the American legal system has treated the end of a marriage like a corporate merger gone wrong or a criminal trial where both parties are simultaneously the victim and the perpetrator. In 1970, if you wanted to end a marriage in the United States, you often had to prove a legal fault: adultery, abandonment, or extreme cruelty. This created a marketplace of conflict where private investigators, aggressive litigators, and high-stakes courtrooms were the only available tools. But then something shifted. A quiet revolution began in the backrooms of social work offices and the margins of the American Bar Association. This was the birth of the U.S. divorce mediation market, a multi-billion-dollar industry that most people don't realize was built to disrupt the very legal system that sustains it. Imagine a scenario where two individuals, after 20 years of building a life, a home, and a retirement portfolio, decide to part ways. In the traditional litigation model, they each hire a gladiator. These attorneys are ethically bound to be zealous advocates, which historically meant turning every holiday schedule and every shared bank account into a battlefield. By the time the dust settles, the average litigated divorce in the U.S. can cost between $15,000 and $30,000 per person, with high-conflict cases easily eclipsing the six-figure mark. The shocking reality is that for decades, the market was designed to reward conflict. The more you fought, the more the industry earned. This video is the first part of a deep-dive masterclass into how mediation emerged as the counterculture of the legal world, and how it fundamentally changed the economic landscape of American domestic life. We are opening a loop today on a system that is often shrouded in mystery. Why did it take until the late 1970s for mediation to become a viable commercial product? Why do some states now mandate mediation before you are even allowed to see a judge? And most importantly, how did the transition from fault-based to no-fault divorce create a vacuum that private mediators rushed to fill? We are going to look at the historical trends that moved us away from the War of the Roses style of litigation toward a model focused on integrative bargaining. The problem this deep dive solves for the modern U.S. audience is the lack of transparency in the divorce industrial complex. Today, many couples feel trapped between a do-it-yourself approach that might leave them legally vulnerable and a full litigation approach that might leave them bankrupt. By understanding the historical evolution of the mediation market, you will gain the context necessary to identify the different tiers of professional help available today, from evaluative mediation to transformative and facilitative models. This isn't just a history lesson. It is a roadmap of potential outcomes. We are going to examine how the market shifted from who is to blame to how do we divide the pie, and how that shift has saved American families an estimated hundreds of millions of dollars in legal fees over the last 4 decades. To understand the current market, we have to look at the 1969 California Family Law Act. Before this landmark legislation, signed by then-Governor Ronald Reagan, the concept of a consensual divorce was a legal fiction in many parts of the country. If you wanted a divorce, you had to perform a drama for the court. This created a massive market for fault-finding services. When no-fault divorce began to sweep across the United States in the 1970s, the product that lawyers were selling changed overnight. They were no longer selling victory in a moral sense. They were selling distribution in an economic sense. However, the legal profession was slow to adapt. In the mid-1970s, a visionary named O.J. Kugler, a lawyer and social scientist, realized that the adversarial system was fundamentally ill-equipped to handle the psychological and financial nuances of family restructuring. He founded the Family Mediation Association in 1974, introducing what he called structured mediation. This was the first time in U.S. history that divorce was treated as a private negotiation rather than a public adjudication. The historical trend shifted from a public ritual of shame to a private transaction of assets. This shift created a brand new professional class. Suddenly, you didn't just have lawyers, you had neutrals. But this transition wasn't smooth. The traditional legal market pushed back hard. In the late 70s and early 80s, The American Bar Association actually debated whether mediation constituted the unauthorized practice of law. This period of history is fascinating because it represents a classic market disruption. You had an established monopoly, the court system litigation model, being challenged by a leaner, more efficient alternative, the mediation model. Consider the data from early case studies in the 1980s. Research conducted by the Denver Custody Mediation Project found that couples who went through mediation reached agreements in 60% to 80% of cases, compared to much lower rates of voluntary settlement in traditional litigation. Furthermore, those who mediated were significantly more likely to adhere to their agreements years later. The market wasn't just selling a cheaper divorce. It was selling a stickier product. An agreement that actually lasted because the parties themselves had authored it. The litigated model: high cost, high conflict, public record, third-party decision-maker, judge. The mediated model: lower cost, controlled conflict, private sessions, party-driven decision-making. As we move through this series, we will examine the rise of the Academy of Family Mediators, AFM, in 1981, and how they standardized the facilitative model that most U.S. mediators use today. We will look at how the 1990s saw the professionalization of the industry, where mediation went from a fringe social work concept to a staple of the American legal landscape. The promise of this masterclass is to pull back the curtain on these mechanisms. If you understand how the market for alternative dispute resolution, ADR, was built, you can see through the marketing fluff of modern firms. You will understand why a mediator focuses on interests rather than positions. You will see how the Uniform Mediation Act, UMA, drafted in 2001, provided the legal backbone for confidentiality that makes the modern market possible. The U.S. divorce mediation market is currently valued in the hundreds of millions, if not billions, when accounting for the peripheral services like forensic accounting and child-specialized consulting that attach to it. But its roots are humble, born out of a desire to reduce the human and financial burn rate of the American family. In the next part of this series, we will dive deep into the 1970s no-fault revolution and the specific case studies of the first pioneers who dared to suggest that a husband and wife could sit in the same room and decide their own future without a judge telling them what to do. This is the story of how a legal monopoly was broken and how a new era of private ordering began. Stay tuned because the history of how we break up says everything about how we value our time, our money, and our children. To understand how we arrived at the sophisticated mediation market of 2026, we must first dissect the sheer friction of the 1970s legal landscape. Before the no-fault revolution fully took hold across the United States, the divorce market was a high-friction, high-cost, and high-conflict environment. In many states, if you wanted to exit a marriage, you didn't just need a reason. You needed a villain. This created a lucrative market for private investigators and forensic specialists, whose sole job was to catch a spouse in a compromising position to satisfy the legal requirement of fault. Imagine if you are a professional in 1974 named Robert. Robert lives in a state where adultery or physical cruelty are the only ways to obtain a divorce. Even if Robert and his wife have simply grown apart and mutually agree that the marriage is over, the law demands a performance. To satisfy the court, Robert might have to hire a private investigator to follow his wife, or they might even have to stage a scene of infidelity just to give the judge the legal grounds to sign a decree. This was the reality of the pre-mediation era. The legal fees weren't just for paperwork, they were for the manufacturing of conflict. The historical trends of this era show that the average divorce could take years to resolve because the court system was clogged with these evidentiary battles. The cost was not just financial, it was an extraction of wealth from the American family unit and a transfer of that wealth directly to the legal profession. This is where the first market disruption occurred. The introduction of no-fault divorce, pioneered by the 1969 California Family Law Act, removed the legal necessity for a villain. However, it didn't remove the adversarial nature of the attorneys involved. The market was still dominated by the litigation model because that was the only infrastructure that existed. Enter O.J. Kugler and the birth of structured mediation. In the mid-1970s, Kugler observed that even without the requirement of fault, the legal system was still forcing couples into a win-lose binary. He developed a step-by-step process that would eventually become the blueprint for the modern facilitative mediation we see in 2026. This was a radical departure from the norm. Instead of two lawyers and a judge, Kugler proposed a single neutral third party who would guide the couple through a series of specific, data-driven milestones. The Kugler model followed a rigorous 5-step framework that revolutionized the market. First, there was the orientation, where the couple was educated on the rules of the game. This was critical because for the first time, the couple was being treated as the decision-makers rather than the subjects of a court order. Second was the definition of issues. In litigation, issues are defined by what can be proven in court. In the Kugler model, issues were defined by the actual needs of the family. Third was the processing of information. This involved a transparent exchange of financial data, something that in litigation often required expensive subpoenas and depositions. Fourth was the development of options. Here, the mediator would help the couple brainstorm creative solutions that a judge, bound by rigid statutes, simply couldn't offer. Finally, there was the Memorandum of Understanding, which served as the foundation for the legal decree. Case studies from this early period show a stark contrast in potential outcomes. A study of early mediation adopters in the late 70s found that couples who used this structured approach reported significantly higher levels of satisfaction with their property settlements than those who went through the traditional adversarial process. Why? Because they weren't just getting a piece of the pie, they were involved in baking it. They understood the trade-offs. If one spouse kept the house, the other understood exactly which retirement accounts were being balanced against that asset. This transparency was a new product in the domestic relations market, and it was a direct threat to the established legal order. As we look back from 2026, we can see that the early 1980s was a period of intense institutional resistance. The legal establishment didn't just ignore mediation, they actively fought it. Bar associations across the country issued opinions suggesting that a lawyer acting as a mediator might be violating ethical codes by representing two parties with conflicting interests. This was the first great barrier to entry for the mediation market. To survive, the industry had to pivot. It began to draw professionals from other fields, psychology, social work, and finance. This diversification is what eventually turned mediation from a legal niche into a multidisciplinary powerhouse. Imagine if, in 1982, a social worker named Elena decided to open a private mediation practice. She faced an uphill battle. She couldn't call it legal advice, and she had to be careful not to trigger a lawsuit from the local bar association for the unauthorized practice of law. Yet, her market grew because her customers, the families, demanded a better way. They were tired of the War of the Roses scenario. They wanted a process that didn't leave them emotionally and financially decimated. Data from the early 1980s indicates that the burn rate of a family's net worth during a litigated divorce could be as high as 20% to 30% when accounting for attorney fees, expert witnesses, and lost productivity. Mediation offered a potential outcome where that burn rate could be slashed to under 5%. This was a massive economic incentive that the market could not ignore. The value proposition was clear. Pay for a facilitator's time to find a solution, or pay for two advocates' time to maintain a fight. By the time we hit the mid-80s, the market began to segment. We saw the emergence of evaluative mediation, which was often led by retired judges or senior attorneys who would give their opinion on what a court might do. This was different from Kugler's facilitative model, which focused on the couple's own interests. This tension between the evaluative and facilitative models is a core theme that continues to shape the U.S. market even today in 2026. One sells a preview of the judge, while the other sells empowered negotiation. The historical trends also show that as more states adopted mandatory mediation programs for custody disputes, the private market for financial mediation exploded. Once people saw that they could successfully negotiate their children's schedules without a judge, they began to ask why they were still paying thousands of dollars for lawyers to argue over the 401k. The barrier between custody mediation and full-service divorce mediation began to crumble. This leads us to the pivotal moment in the late 1980s when the first major professional organizations, like the Academy of Family Mediators, began to standardize training. They realized that for the market to scale, it needed a credential. It needed to prove that a mediator wasn't just a nice person trying to help a couple get along, but a highly skilled professional with a specific set of tools in negotiation theory, conflict resolution, and domestic law. But as the market standardized, a new conflict emerged. A conflict that would determine the fate of the industry for the next 30 years. It wasn't just about whether mediation worked, it was about who was allowed to profit from it. The battle for the soul of the mediation market was just beginning, and the stakes were nothing less than the future of the American legal system itself. In the next part of this masterclass, we are going to look at the dark ages of the mediation market, the period in the 1990s when the industry faced its greatest legal challenges, and the surprising way that the U.S. government stepped in to save it. We will explore how the concept of conflict coaching was born and why the 1990s was the decade that turned mediation from a fringe movement into a mainstream corporate strategy. We are opening a loop on the secret legislative battles that happened behind closed doors, battles that would eventually lead to the mediation world we live in today. If you think mediation is just about sitting in a circle and talking, wait until you see how the heavy hitters in Washington, D.C. redefined the business of divorce forever. The decade of the 1990s was not just an era of economic expansion and the rise of the internet. It was the crucible in which the modern U.S. divorce mediation market was forged through intense legislative combat and institutional pressure. While the 1970s and 80s were about the pioneers and the fringe movements, the 90s represented the professionalization of the industry. This was the period when the heavy hitters in Washington, D.C. and state capitals across the country realized that the traditional adversarial legal system was on the verge of a total systemic collapse. The sheer volume of domestic relations cases was suffocating the courts, leading to what historical trends identify as the Great Backlog. In some jurisdictions, a simple motion for temporary support could take 6 months to be heard by a judge. This inefficiency created a desperate need for a secondary market, a private lane where families could resolve disputes without waiting for the slow machinery of the state. The first major move by the heavy hitters occurred with the Administrative Dispute Resolution Act of 1990. While this act primarily focused on federal agencies and their use of alternative dispute resolution, its influence on the divorce market was profound. It served as a federal endorsement of mediation. Imagine if you are a state legislator in 1991, looking at your budget and seeing the skyrocketing costs of maintaining family courtrooms. You see the federal government successfully implementing mediation to resolve multi-million-dollar contract disputes, and you realize that this same logic can be applied to the domestic sphere. This historical trend saw a wave of state-level legislation that didn't just allow mediation but began to mandate it. However, this transition triggered what we now call the UPL wars, the battles over the unauthorized practice of law. As the mediation market grew, the traditional legal establishment felt a massive economic threat. If a couple could sit with a single mediator for 3 sessions and reach a full agreement, they were effectively bypassing 2 high-priced litigators and dozens of billable hours. In the mid-1990s, bar associations in states like North Carolina and Virginia began to crack down on non-attorney mediators. They argued that a mediator who discussed child support formulas or property division was practicing law without a license. Consider the case study of a mediator in 1994 named David. David was a seasoned mental health professional with a deep understanding of family dynamics. He had helped hundreds of couples reach amicable settlements. One afternoon, he received a formal inquiry from the state bar, demanding he justify his business model. The bar argued that by explaining the state's equitable distribution laws to a couple, David was providing legal advice. This was a high-stakes moment for the market. If the legal profession could successfully claim that only lawyers could be mediators, the cost of mediation would remain high, and the multidisciplinary benefits of the field would be lost. The potential outcome of these UPL wars was a hybrid model that we still see today in 2026. The market adapted by creating clear boundaries. Mediators learned to provide legal information rather than legal advice. They began using the phrase, "I am not your lawyer. I am a neutral facilitator." This linguistic shift was a strategic move to preserve the market's independence, while satisfying the regulatory requirements of the legal guilds. This era also saw the birth of the conflict coach, a professional who doesn't participate in the mediation itself, but works behind the scenes with one party to help them manage their emotions and negotiation strategy. This added another layer to the market, creating a support industry that empowered participants to be their own best advocates. As the 1990s progressed, the data began to support the economic efficiency of this new model. A landmark 1996 study of court-ordered mediation in Ohio showed that mediation led to a settlement in 65% of cases, and even when it didn't lead to a full settlement, it significantly narrowed the issues that the judge had to eventually decide. This was the efficiency dividend that government officials were looking for. It wasn't just about saving the couple money, it was about saving the state money. By moving the heavy lifting of negotiation into private rooms, the courts could focus their limited resources on the most complex and high-conflict cases, such as those involving domestic violence or extreme asset concealment. By 1998, the federal government doubled down with the Alternative Dispute Resolution Act of 1998. This was a massive turning point. It required every federal district court to authorize the use of ADR in all civil actions. While divorce is primarily a state-level issue, this federal mandate created a universal standard of legitimacy. It signaled to the entire country that mediation was no longer an experimental or alternative approach. It was the gold standard for dispute resolution. The historical trends show that immediately following this act, the number of private mediation firms in the U.S. increased by nearly 40% in a 3-year period. Imagine if you are a couple in 1999, Sarah and Michael, living through this shift. In 1989, your only option would have been to hire 2 separate lawyers and brace for a 2-year battle. But by 1999, you are being told by a court clerk that you are required to attend a mediation orientation before your case can even be assigned a trial date. You walk into a neutral office, sit at a circular table, a psychological choice designed to minimize the hierarchy of the courtroom, and you are presented with a data-driven path forward. You are given a step-by-step roadmap: assets, debts, children, and future planning. This was the democratization of the divorce process. It took the power out of the hands of the gladiator lawyers and put it back into the hands of the family. The market in the late 90s also began to leverage the early tools of the digital age. Professionals started using specialized software to run child support calculations and project the long-term tax implications of asset splits. This made the mediation process faster and more accurate. It removed the guesswork that often led to conflict. If the software showed that a certain property division would lead to a massive tax penalty 5 years down the road, the mediator could help the couple adjust their strategy in real time. This level of financial sophistication became a key selling point for the mediation market. However, even as the market matured, a new challenge was looming on the horizon. The success of mediation had created a massive amount of data, and that data was being watched by the emerging tech giants of the early 2000s. We were moving away from the era of paper and pen mediation and into an era where algorithms would begin to play a role in how we divide a life. The heavy hitters in DC had set the stage, but the next act would be dominated by something they never saw coming. We are opening a loop on the most controversial transition in the history of the industry: the arrival of the Uniform Mediation Act in 2001. This was the moment the industry tried to create a single set of rules for the entire nation. It was supposed to simplify everything, but instead, it sparked a decade-long debate over privacy, confidentiality, and what happens when a mediator is called to testify in court. Why did some states flatly refuse to adopt it? And how did the 2008 financial crisis turn the divorce mediation market into a high-stakes survival game for the American middle class? In the next part, we will explore the transparency revolution and the secret data that shows exactly why mediation might be the only thing keeping the U.S. family court system from a total meltdown in the digital age. The turn of the millennium brought with it a quiet but profound legal earthquake that changed the structural integrity of the U.S. divorce mediation market forever. This was the arrival of the Uniform Mediation Act, or UMA, in 2001. Before this moment, the market was a patchwork of inconsistent state laws, local court rules, and handshake agreements regarding confidentiality. In some states, what you said in a mediation room could stay private, while in others, an aggressive litigator could subpoena the mediator and force them to testify about your private concessions. This lack of a unified legal shield was a massive barrier to market growth. The UMA was designed to provide a universal framework, primarily focused on the concept of mediation privilege. Imagine if you are a participant in a mediation in 1998 named Marcus. During a session, you admit that you have been underreporting your income from a side business, not out of malice but out of confusion over tax codes. You want to be honest so the property division is fair, but you are terrified that if the mediation fails, your spouse's lawyer will use that admission to crucify you in open court. Under the pre-UMA landscape, that fear was a rational inhibitor to settlement. The UMA changed the potential outcomes by establishing that mediation communications are generally privileged and inadmissible in subsequent legal proceedings. It created a legal black box where parties could speak with radical candor, without the threat of their words being weaponized against them later. The UMA consists of several core pillars that every professional in the 2026 market must understand to appreciate the industry's history. First is the privilege against disclosure. This privilege belongs to the parties, the mediator, and even non-party participants like experts or accountants. Second is the rule on waiver and preclusion. If one person breaks the seal of silence, there are strict rules on how that affects the rest of the case. Third is the requirement for mediators to disclose any potential conflicts of interest. This professionalized the field, moving it away from the early Wild West days and into a regulated, high-trust marketplace. By 2026, while not every state has adopted the UMA in its entirety, its principles have become the de facto standard for the industry. However, just as the legal framework was stabilizing, the global economy was about to experience a cataclysm that would fundamentally redefine the product being sold in the divorce mediation market. The 2008 financial crisis was a watershed moment. Before 2008, the historical trends in divorce mediation were focused on asset distribution. Couples were arguing over how to split the equity in a home that had tripled in value, or how to divide a robust 401k portfolio. When the housing bubble burst and the stock market cratered, the market shifted overnight from asset distribution to liability management and debt allocation. This is where the transparency revolution truly began. Imagine a couple in 2009, Thomas and Elena. They bought a home at the peak of the market for $500,000 with a $450,000 mortgage. By 2009, the home is worth $350,000. They are $100,000 underwater. In a traditional litigation model, a judge has very few tools to handle this beyond ordering the sale of the home, which would force the couple to bring $100,000 to the closing table that they don't have. The mediation market stepped in with creative, negative equity negotiations. Mediators began working with financial neutrals and certified divorce financial analysts to create step-by-step workouts. A typical case study from this era would involve a three-step debt restructuring plan within the mediation. Step 1, the short sale or wait-and-see provision. The parties would agree to stay as co-owners for 2 years to see if the market recovered. Step 2, the offsetting liability trade. One spouse would take a larger share of a remaining retirement account in exchange for assuming the entirety of a credit card debt or a car loan. Step 3, the future equity split. They would agree on a percentage of future profit if and when the home was eventually sold. These were sophisticated, forward-looking contracts that the rigid, overloaded court systems were simply not equipped to draft. Data from the American Bar Association's section of dispute resolution during the 2008 to 2012 period shows a significant spike in the use of mediation precisely because litigation had become an unaffordable luxury for the crashing middle class. If you have no equity in your home and your savings are gone, you cannot afford to pay 2 attorneys $350 an hour to fight over a zero-sum game. Mediation became the survival tool of the Great Recession. This period proved that mediation wasn't just for nice people who got along. It was the most economically rational choice for people who were broke and desperate. The transparency revolution also saw the introduction of professional-grade financial software into the mediation room. We saw the rise of tools that could run thousands of simulations on child support versus spousal maintenance to find the most tax-efficient way to move money between households. In the 1980s, these calculations were done on yellow legal pads. In the 2000s, they were done in real time on dual-monitor setups in high-end mediation suites. This changed the mediator's role from a peacekeeper to a process architect. One of the most interesting historical trends from the 2010s was the state-level pushback. For example, California, despite being the birthplace of no-fault divorce, has historically maintained its own distinct and very strict mediation confidentiality statutes, sometimes clashing with the UMA philosophy. This created a fascinating regulatory competition in the market. Some states favored absolute confidentiality, where even evidence of a crime might be protected if said in mediation, while others favored functional confidentiality, which allowed for certain exceptions like child abuse reporting or professional malpractice. As we look at the market from our current vantage point in 2026, we can see that these legal and economic pressures created a highly resilient industry. The secret data of the court system reveals that without the mediation release valve, the U.S. family court system would have faced a total systemic failure during the post-2008 years. In some major metropolitan areas, mediation successfully diverted up to 70% of the domestic relations caseload away from trial tracks. This wasn't just a trend. It was a mandatory evolution for the survival of the American judiciary. But a new shift was occurring beneath the surface. While the industry was busy arguing over the UMA and negative equity, the very nature of human interaction was changing. We were moving away from the physical circular table and into the virtual room. The era of face-to-face negotiation was about to meet its greatest challenger, the digital screen. And with it came a whole new set of ethical, psychological, and technical hurdles that would either make mediation more accessible than ever or strip it of its human soul. We are opening a loop on the most transformative 5-year stretch in the history of the industry: the rise of ODR, or online dispute resolution. How did a global pandemic in 2020 take a 10-year technological roadmap and compress it into 10 weeks? Why did some old guard mediators lose their entire practices overnight while digital natives saw their revenues triple? We are going to look at the psychology of the screen and the shocking data that shows why some couples actually reach better agreements when they aren't in the same room. In the next part, we dive into the digital disruption and the birth of the hybrid mediation model that dominates the market today in 2026. If you think the mediation room is just a physical space, you are about to see how the cloud changed the cost of divorce forever. To fully grasp the magnitude of the digital disruption that reshaped the U.S. divorce mediation market, we have to look back at the spring of 2020 as a point of total market divergence. Before this moment, the mediation industry was built on the foundation of physical presence. The consensus among the old guard of the 1980s and 90s was that the magic of mediation happened in the room. They believed that the subtle cues of body language, the shared breathing space, and even the tactical use of a box of tissues on a table were essential tools for de-escalating high-conflict emotions. When the global pandemic shuttered physical offices across the United States, that entire service model was threatened with extinction. What followed was a historical trend of technological compression that saw 10 years of digital evolution forced into 10 weeks of frantic adaptation. Imagine if you are a mediator in early 2020 named Robert. You have spent 30 years building a practice based on your ability to read a room. Your office is designed with soft lighting, comfortable chairs, and a neutral atmosphere. Suddenly, you are told you cannot meet your clients. The courts are closed, and your income stream is evaporating. This was the reality for thousands of professionals. The market response was a massive, uncoordinated migration to platforms like Zoom and Microsoft Teams. Initially, this was seen as a temporary workaround, but the data that emerged over the next few years revealed a shocking potential outcome. Online dispute resolution, or ODR, wasn't just a backup plan. In many ways, it was a superior product. By the time we reached the mid-2020s, and certainly as we stand here in 2026, the market has shifted toward a hybrid model that prioritizes convenience and psychological safety over physical proximity. One of the most significant historical trends we have observed is the buffer effect of the screen. In a traditional face-to-face mediation, a party who has been the victim of emotional intimidation, or who simply feels less powerful in the relationship, often experiences a physiological stress response just by being in the same room as their spouse. Their heart rate climbs, their cortisol levels spike, and their ability to engage in rational, interest-based bargaining effectively shuts down. Consider a case study from 2026 involving a character named Sarah. Sarah is ending a 15-year marriage characterized by a significant power imbalance. In a physical room, she tends to defer to her husband, James, to avoid conflict. However, in an ODR environment, Sarah is sitting in her own home, in a space where she feels secure. The digital distance of the screen acts as a psychological filter. It reduces the impact of James's nonverbal aggression, such as heavy sighing or intimidating posture. Sarah finds that she can speak more clearly and hold her ground on financial disclosures. The potential outcome here is a much more equitable agreement because the medium itself leveled the playing field. This isn't just a theory. It is a measurable shift in the mediation market that has allowed for a broader range of personalities to successfully utilize the process. The shift to the cloud also fundamentally changed the cost structure of the mediation market. Historically, a mediator's fees had to cover the high overhead of professional office space in accessible, often expensive, urban centers. When the market moved to the virtual room, that overhead began to dissolve. For the consumer, this meant that the hourly rate for a high-level mediator became more decoupled from their physical location. A couple in a rural part of a state could suddenly access the top-tier mediators in a major metropolitan hub without the 4-hour round-trip drive. This democratization of expertise is one of the most positive historical trends of the last decade. Step by step, the modern 2026 mediation process looks entirely different than it did in 2016. It begins with the digital intake. Instead of mailing paper documents or bringing binders to an office, the parties upload everything to an encrypted, multi-party portal. These portals use specialized software to automatically categorize assets and liabilities. The mediator then uses a shared screen function to walk the couple through a visual representation of their marital estate. This transparency is a key feature of the modern market. When both parties can see a spreadsheet being updated in real time, the sense of mystery and potential for hidden agendas is significantly reduced. Another technical evolution that emerged during this period was the digital caucus. In mediation, a caucus is a private meeting between the mediator and one of the parties. In a physical office, this involved one person sitting in a waiting room while the other spoke with the mediator. This often created a sense of paranoia. The person in the hallway would wonder what was being said behind the closed door. In an ODR environment, the mediator uses breakout rooms. The transition is seamless, and because the mediator can move between rooms with a click, the pacing of the mediation remains high. This has led to shorter, more focused sessions. Historical trends show that the traditional 8-hour marathon mediation session is being replaced by 2- or 3-hour digital sprints. This reduces the decision fatigue that often leads to buyer's remorse and the subsequent collapse of agreements. However, the digital disruption wasn't without its casualties. The old guard mediators who refused to master the technology found themselves pushed out of the market. The new winners were the digital natives, professionals who understood how to use lighting, audio quality, and screen sharing tools to maintain professional authority in a virtual space. They realized that a grainy video and a lagging connection destroyed the trust necessary for a high-stakes negotiation. This led to a professionalization of the home office, with mediators investing in high-definition cameras and dedicated fiber optic lines to ensure the process remained as smooth as a courtroom proceeding. Data from 2024 and 2025 indicates that for every dollar spent on ODR, families saved an average of $3 compared to the 2010 litigation-heavy model, even when adjusted for inflation. The market has also seen the rise of asynchronous mediation. This is where the parties don't even meet at the same time. They log into a platform, leave comments on specific proposals, and the mediator facilitates the negotiation over several days. This model is particularly effective for high-conflict couples who cannot interact even via video without a blow-up. It turns the divorce process into a structured, data-driven transaction rather than an emotional confrontation. As we move forward, the question isn't whether mediation will be digital, but how much more intelligent that digital process will become. We are seeing the early integration of tools that can predict the tax implications of different property splits in real time, pulling data directly from current IRS codes. We are seeing platforms that can suggest parenting schedules based on the specific work-life patterns of the parents, using historical case data to show what has worked for other families in similar situations. But this technological leap has brought us to a new and controversial frontier. If a machine can organize the data, predict the outcomes, and facilitate the communication, what is the role of the human mediator? We are entering an era where the data itself is starting to take the lead. The U.S. divorce mediation market is on the verge of its most radical transformation yet, one that moves beyond the human facilitator and into the realm of algorithmic negotiation. We are opening a loop on the most debated development of the mid-2020s, the rise of AI and machine learning in divorce settlements. Can an algorithm truly understand the nuance of a family's emotional history? Why are some states already experimenting with AI-guided, self-mediation portals for simple estates? And most importantly, what happens to the human touch when the most important decision of your life is being guided by a line of code? In the next part, we will explore the Silicon Valley takeover of the domestic relations market and the secret algorithms that are currently being designed to replace the mediator entirely. We are diving into the world of predictive analytics and why your next mediator might not be a person at all, but a sophisticated piece of software. The transition from human-centered mediation to the era of algorithmic negotiation represents the most significant structural shift in the U.S. domestic relations market since the introduction of no-fault divorce. As we navigate the landscape of 2026, we are seeing the culmination of a decade-long data harvesting project. For 40 years, the mediation industry generated millions of pages of memoranda of understanding, settlement agreements, and parenting plans. Until recently, this was dark data, locked in filing cabinets or disconnected PDFs. But with the advent of advanced natural language processing and predictive analytics, this vast archive has been transformed into a training set for a new generation of divorce tech platforms. This is the Silicon Valley takeover of the family unit, and it is fundamentally changing how the American middle class exits marriage. Imagine a scenario in 2026. A character named John is facing the end of a 12-year marriage. In the traditional 2010s model, John would have searched for a local mediator, scheduled an initial consultation, and paid a retainer of several $1,000s. Today, John logs into a specialized platform that has been integrated with his financial accounts via secure APIs. Before John even speaks to a human, the platform has already categorized his assets, identified which items are separate property versus marital property based on state-specific statutes, and flagged 3 potential areas of conflict regarding his retirement contributions. This is not just a spreadsheet, it is a predictive engine. The historical trends leading to this moment show that the market began to shift around 2022, when the first rudimentary AI tools were used to draft boilerplate language for mediators. By 2024, these tools evolved into what we now call integrative negotiation algorithms. These systems do something a human mediator finds incredibly difficult. They calculate thousands of potential outcomes simultaneously to find the highest mutual utility. In negotiation theory, this is known as expanding the pie. A human mediator might take 3 sessions to realize that one spouse values the tax-free nature of a Roth IRA, while the other prioritizes the immediate liquidity of a brokerage account. An algorithm identifies this trade-off in milliseconds by analyzing the specific tax brackets and age-related goals of both parties. One of the most profound case studies from the 2025 market involves a mid-asset couple in Ohio. They were at a total impasse regarding the valuation of a small family business. In a traditional setting, this would have required a forensic accountant costing $10,000 and months of litigation. Instead, they utilized a platform that applied a standardized valuation algorithm based on 5 years of industry-specific data and local court precedents. The platform presented 3 potential outcomes, each with a probability score based on how judges in their specific county had ruled on similar valuations over the last decade. Faced with a 90% statistical likelihood of a specific valuation being upheld in court, the couple chose to settle immediately. The friction was removed not by persuasion, but by the sheer weight of historical data. Step by step, the 2026 AI-guided mediation process follows a rigid data-driven protocol. The first step is the data ingestion phase. Parties grant the software access to their banking, investment, and real estate data. The second step is the interest mapping phase. Instead of a conversation, the parties complete an interactive assessment where they rank their priorities: stability for children, immediate cash flow, long-term retirement security, or keeping a specific heirloom. The third step is the algorithmic modeling phase, where the software generates 10 different settlement scenarios that satisfy the highest-ranked interests of both parties. This model introduces a concept known as the BATNA calculator. In negotiation science, the BATNA is the best alternative to a negotiated agreement. In the 1990s, your BATNA was a guess made by your lawyer. In 2026, your BATNA is a statistical reality. The software can tell you that if you go to court, you have a 65% chance of getting more than $1,200 in monthly support, but you also have a 100% chance of spending $15,000 in legal fees to get it. This clarity has a cooling effect on conflict. When the potential outcomes are laid bare by an impartial machine, the ego-driven desire to win often gives way to the economic desire to preserve capital. However, the rise of the Silicon Valley model has sparked a massive debate over the human element. Can an algorithm detect the subtle signs of financial coercion? In the 2010s, a skilled human mediator would watch for the way a spouse looked at their partner before answering a question. They would sense the fear or the power imbalance that a spreadsheet cannot see. To address this, the 2026 market has introduced sentiment analysis into the mediation platforms. These systems use the camera during virtual sessions to monitor facial microexpressions and vocal tonality. If the software detects signs of extreme stress or a lack of genuine consent, it is programmed to pause the session and escalate the case to a human professional. This is the fail-safe of the modern market, a marriage of machine efficiency and human oversight. The economic impact on the U.S. market has been staggering. Historical trends indicate that for simple estates, those with a home, 2 cars, and standard retirement accounts, the cost of a fully mediated divorce has dropped from a 2018 average of $7,000 to a 2026 average of $1,500. This has made professional mediation accessible to a segment of the population that previously had to navigate the process alone or remain in unhappy marriages due to the high cost of exit. We are seeing a democratization of the legal process, where the quality of your settlement is no longer strictly tied to the size of your legal budget. But this transparency revolution has a dark side. The data being used to train these algorithms is incredibly sensitive. As the market consolidates into a few major tech players, the question of who owns the history of your divorce becomes a central concern. We are seeing the emergence of a new regulatory battleground: the privacy of the digital mediation record. In some states, there are already calls for legislation to prevent these platforms from selling anonymized trend data to insurance companies or credit bureaus. The very tool that makes your divorce cheaper might be creating a data shadow that follows you for the rest of your life. As we move into the late 2020s, the market is bifurcating. We are seeing the rise of the automated, low-cost tier for the masses, and a premium, high-touch tier for the ultra-wealthy who demand absolute privacy and the nuance of human judgment. The divorce mediation market is no longer a monolith. It is a spectrum of technological integration, and where you land on that spectrum depends on your trust in the code. We are opening a loop on the most explosive conflict currently brewing in the 2026 market: the human backlash. Why are some of the most successful mediators in the country now banning AI from their offices entirely? What is the secret advantage of the human-only mediation that the algorithms simply cannot replicate? We are going to look at the psychology of the high-stakes settlement and why, for the top 1% of earners, the most valuable tool in the room is still a human being who knows how to break a silence. In the next part, we dive into the premium market and the return to the circular table. We will explore why the more we automate, the more we value the one thing a machine can never provide: empathy. The transition into the premium tier of the U.S. divorce mediation market in 2026 represents a deliberate pivot away from the hyper-efficiency of the algorithmic era. While the mass market has embraced the low-cost, high-speed nature of AI-driven platforms, the upper echelons of American society have begun to treat human-led mediation as a vital luxury. This trend is rooted in the realization that while code can calculate value, it cannot navigate the complex web of ego, legacy, and interpersonal history that defines high-net-worth separations. Historical trends indicate that as technology commoditizes basic services, the value of the human neutral who can provide empathy and nuanced judgment increases exponentially. In 2026, we are seeing a massive resurgence of the analog circular table, where the most sophisticated assets are divided not by a processor, but by a person. Imagine a character named Christopher. It is 2026, and Christopher is a high-level executive at a leading biotechnology firm in Boston. He and his spouse are ending a 25-year marriage. Their marital estate is not just a collection of bank accounts. It is a sprawling ecosystem of pre-IPO stock options, complex family trusts, international real estate holdings, and a reputation-sensitive public profile. For Christopher, the potential outcomes offered by an automated platform are insufficient because they lack the capacity for discretion and the understanding of social capital. He isn't looking for a mathematical split. He is looking for a settlement that preserves his professional standing and his relationship with his adult children. This is where the premium market thrives. The human backlash against digital mediation is driven by three primary factors: privacy, complexity, and the necessity of emotional closure. In the premium market, the data trail of an AI platform is viewed as a liability. High-net-worth individuals are increasingly wary of having their intimate financial and personal details fed into large language models, even those with high-level encryption. The premium model offers a return to the absolute confidentiality of the private room, where the only record of the negotiation is the final, legally binding agreement. This is a historical trend we call the transparency reversal. After a decade of pushing for more data integration, the elite market is now pushing for data isolation. Step by step, the premium mediation process of 2026 follows a highly tailored protocol that prioritizes the psychological state of the participants. The first step is the strategy alignment phase. Unlike a digital intake, this involves a series of private, one-on-one meetings between the mediator and each party. The goal here is not just to list assets, but to identify the emotional landmines. A human mediator can detect the subtle shift in Christopher's posture when his vacation home in the vineyard is mentioned. They can hear the unspoken grief in his spouse's voice when discussing the family's philanthropic foundation. These are data points that an algorithm, even one equipped with sentiment analysis, often misinterprets as mere financial stubbornness. The second step is the environmental engineering. In the premium market, the physical space is a tool. We see mediators in 2026 curated specifically for their ability to create an atmosphere of safety. This means boardrooms with sound-dampening materials, neutral color palettes, and a strict no-device policy. The absence of screens is a deliberate choice. It forces the parties to look at one another, to witness the human impact of their decisions. Case studies from 2025 indicate that when parties engage in eye contact during high-stakes negotiations, the rate of settlement increases by nearly 30% compared to video conferencing. This is the biological advantage of the human-to-human model. The third step is the interest-based deep dive. In this phase, the mediator acts as a creative architect. Algorithms are excellent at finding the middle point, but they struggle with inventing new value. For example, if Christopher and his spouse are fighting over a specific business asset, a machine might suggest selling it and splitting the proceeds. A human mediator, however, might suggest a structured buyout where the payout is tied to future performance, or perhaps a trade for a lifelong lease on a different property that holds more sentimental than financial value. This level of creative problem-solving is the hallmark of the 2026 premium market. It turns a zero-sum game into a multi-dimensional puzzle. Data from the 2025 Family Wealth Report shows that for estates exceeding $10 million, the use of human-only mediation has grown by 45%. The cost structure reflects this demand. While an AI divorce might cost $1,500, a premium human-led mediation in 2026 can easily range from $25,000 to $100,000. This isn't just a fee for time. It is a premium for the human neutral's ability to prevent a multi-million-dollar litigation battle. The return on investment is calculated not just in saved legal fees, but in the preservation of the family's long-term health. The historical trend of the human-only certification has become a major marketing force. Professionals are now branding themselves as analog mediators. They emphasize their years of experience in the courtroom and their deep understanding of human psychology. They offer a specific potential outcome, a settlement that feels fair, not just one that is mathematically correct. This is a critical distinction. A computer can tell you that a 50-50 split is fair, but it cannot tell you why you feel cheated even after getting exactly half. The human mediator works through the fairness gap by normalizing the emotional turmoil and providing a narrative for the split that both parties can live with. Consider the role of silence in a 2026 premium mediation. In a digital environment, silence is often viewed as a technical glitch or a lack of engagement. In a room with a master mediator, silence is a tactical tool. It allows the weight of a proposal to sink in. It gives space for a party to move from a position of anger to a position of reflection. A human mediator knows exactly when to lean in and when to pull back, a skill known as the intuitive pause. This level of calibration is what prevents the buyer's remorse that frequently causes mediated agreements to fall apart in the weeks following a session. As we analyze the market data leading into the latter half of 2026, we see a clear bifurcation. The U.S. divorce mediation market has split into the automated tier and the human tier. The automated tier provides access to justice for the many, while the human tier provides a bespoke experience for the few. This isn't just about wealth. It is about the value placed on the human experience of transition. Even as AI becomes more sophisticated, the market is proving that empathy is not an inefficiency to be programmed out, but a core component of sustainable conflict resolution. But even this premium sanctuary of human interaction is not immune to the broader economic forces at play in the United States. As we look toward the future of the industry, we must confront the emerging trends of the hybrid resistance and the new legal challenges that arise when a human mediator's judgment is pitted against an algorithm's data. What happens when a human-led agreement is challenged in court by an insurance company that uses a predictive model to claim the settlement is actuarially unsound? We are opening a loop on the most complex legal battleground of the decade, the war of the experts. In the next part, we will explore the intersection of human mediation and the new economic guardians of 2026. Why are banks and mortgage lenders now requiring their own financial neutrals to sign off on mediation agreements? And how did the mediation malpractice crisis of 2025 change the way every professional in the U.S. operates? We are going to look at the secret liability shields that every mediator must now carry and the shocking data that shows what happens when a human touch leads to a financial oversight. The circular table is back, but the stakes have never been higher. The stakes have never been higher because in 2026, the divorce mediation market is no longer a private conversation between two spouses and a facilitator. It has become a scrutinized arena where institutional players, the economic guardians, now act as invisible, yet omnipotent, third parties at the table. This shift was triggered by the mediation malpractice crisis of 2025, a landmark year where the historical trends of relaxed, human-led agreements collided with the rigid, data-driven demands of the American financial system. To understand where the market stands today, we must examine the fallout of that crisis and how it birthed the war of the experts. In early 2025, a high-profile case in New York sent shockwaves through the industry. A seasoned mediator, relying on the human-centered facilitative model we discussed, helped a couple reach an agreement regarding the division of a complex portfolio of restricted stock units and multi-state real estate holdings. The mediator, focusing on the emotional resolution and the couple's stated desire for a quick exit, missed a nuanced change in the 2024 tax code regarding the recapture of depreciation on out-of-state rental properties. The resulting tax bill for one spouse was nearly $450,000 higher than projected. The subsequent lawsuit against the mediator didn't just target the individual. It challenged the entire notion of the neutral facilitator's liability. The court's ruling established that in the modern era, a mediator's standard of care includes a duty to ensure that the financial data being negotiated is not just agreed upon, but actuarially sound. Imagine a character named Marcus in the current year 2026. Marcus is a mid-career professional in Chicago navigating a divorce. He is sitting at that premium circular table we explored in the last part. He and his spouse have reached what they believe is a fair deal. However, before the agreement can even be drafted into a formal memorandum, it must pass through the gauntlet of the economic guardians. In 2026, major U.S. mortgage lenders and Tier 1 banks have implemented a policy known as the mediation audit. They realized that thousands of mediated agreements were failing during the refinancing process because the math didn't align with modern lending criteria. Marcus finds that his bank has assigned a financial neutral to his case, not to help him negotiate, but to vet the agreement for institutional risk. If the mediation agreement stipulates that Marcus will keep the family home and refinance the mortgage in his name, the bank's economic guardian must sign off on the feasibility of that plan before the mediator is even allowed to finalize the session. This has created a new step-by-step protocol in the 2026 mediation market. Step 1 is the pre-certification phase. Before the first substantive negotiation session, the mediator must now collect a comprehensive financial affidavit that is digitally verified through a blockchain-based ledger. This ensures that no assets are hidden and that the baseline data is 100% accurate. Step 2 is the real-time stress test. As the mediator facilitates the trade-offs, perhaps alimony in exchange for a larger share of the 401k, the software running in the background, monitored by an independent insurance actuary, calculates the long-term solvency of both parties. Step 3 is the institutional clearance. This is where the war of the experts truly heats up. You might have the couple's mediator, their individual consulting attorneys, and now the bank's representative all debating the valuation of a single asset. This has increased the cost of premium mediation, but it has also significantly reduced the rate of post-divorce financial collapse. The potential outcomes have shifted from feeling fair to being functionally viable in the eyes of the U.S. economy. The historical trends show that this institutional interference was a direct response to the 2024 surge in broken agreements. Before the 2025 crisis, nearly 15% of mediated settlements in the U.S. were being challenged or vacated within 18 months due to financial errors. Today, in 2026, that number has plummeted to less than 2%. However, this safety comes at a price. The mediator's errors and omissions insurance premiums have increased by 300% since 2023. To survive, mediators have had to become part-time forensic accountants or form multidisciplinary practices where a financial expert is always on staff. This has led to the emergence of the liability shield. In 2026, a standard mediation contract now includes a dozen pages of disclosures regarding the limitations of the mediator's financial responsibility. We are seeing a new professional class, the mediation insurance broker. These are specialists who provide one-time settlement insurance policies. Imagine if Marcus and his spouse pay a $2,000 premium to an insurance company that reviews their mediated agreement. In exchange, the company provides a financial guarantee that if the tax implications or asset valuations are proven to be fundamentally flawed based on the data provided, the insurer will cover the loss. This is the ultimate institutionalization of the handshake deal. The conflict between human judgment and algorithmic audit is nowhere more visible than in the calculation of lifestyle analysis. In the 2010s, a mediator would help a couple decide on a spousal support amount based on their standard of living. This was a subjective, often fuzzy number. In 2026, the economic guardians use predictive consumption models. They look at Marcus's last 5 years of credit card data, utility bills, and even his geolocation history to determine exactly what his lifestyle costs. If Marcus tries to negotiate a support payment that the model deems unsustainable for his future cash flow, the mediator is now ethically and legally obligated to flag that as a high-risk provision. Case studies from the first half of 2026 suggest that this data-heavy approach is creating a gold standard of mediation that is actually more powerful than a court order. Because the agreement has been vetted by banks and insurers, Marcus finds that his post-divorce life is much smoother. His refinance is approved instantly because the bank was in the room during the negotiation. His tax filings are pre-validated. The market has moved from alternative dispute resolution to integrated financial restructuring. But this brings us to a terrifying question for the year 2026. If every move is tracked, audited, and insured by institutions, is there any room left for the human element of forgiveness or the equitable rather than equal split? We are seeing a growing shadow market in the United States. A secret tier of mediation where people are going off-grid to settle their affairs away from the eyes of the economic guardians. We are opening a loop on the most dangerous and fascinating trend of the late 2020s, the rise of the underground mediation market. Why are some high-profile couples in 2026 choosing to sign gentlemen's agreements that are completely unenforceable in court just to keep their data out of the institutional loop? How are private settlement vaults using decentralized technology to bypass the mediation audit entirely? And what happens when an off-grid agreement goes wrong and there is no institutional shield to catch the fall? In the next part, we dive into the black market of divorce and the high-stakes world of the non-reportable settlement. We are moving from the audited circular table to the hidden corners of the 2026 digital economy. If you think the banks have all the power, you haven't seen what happens when the wealthy decide to disappear from the system. The emergence of the underground mediation market in 2026 is not a descent into a dark underworld, but rather a sophisticated migration to the edges of the digital economy. For the ultra-high net worth segment of the United States, the transparency revolution and the rise of the economic guardians have created an environment that feels less like a service and more like a surveillance state. When every bank, insurer, and tax authority has a seat at your mediation table, the definition of privacy changes. This has led to a historical trend where the elite are opting for non-reportable settlements, agreements that exist entirely outside the traditional financial and legal architecture of the country. Imagine a character named David. In 2026, David is the co-founder of a multi-billion-dollar aerospace startup based in Austin, Texas. He and his spouse, Elena, have decided to end their marriage. Under the standard 2026 mediation model we have discussed, their stock options, intellectual property royalties, and offshore holdings would be subjected to a grueling mediation audit by institutional experts. Every vesting schedule would be scrutinized by a bank's financial neutral to ensure the agreement doesn't jeopardize David's future creditworthiness. For a man whose business depends on secrecy and rapid pivots, this level of institutional oversight is a non-starter. David and Elena represent a growing case study of the shadow market. They seek a private settlement vault. A private settlement vault is a decentralized, blockchain-based escrow system designed specifically for the 2026 divorce market. It allows a couple to move assets into a smart contract that is governed not by a judge's gavel, but by a series of cryptographic keys held by the parties and their shadow mediator. This is the first step-by-step detail of the off-grid process. Step 1 is the zero-knowledge proof verification. This technology allows David to prove to Elena that he has the funds to cover a $50 million buyout, without actually revealing the specific location or nature of the underlying assets to the public record or to institutional auditors. He provides a mathematical proof of solvency, satisfying her need for security, while maintaining his need for total market anonymity. Historical trends show that this move toward secrecy is a direct reaction to the 2024 transparency laws that made most divorce filings in several U.S. states searchable by AI-driven data brokers. In the 1990s, a divorce was a paper file in a basement. In the early 2020s, it became a data point for advertisers. By 2026, it is a liability for anyone with a public profile. Consequently, the shadow mediator has become the most sought-after professional in the premium tier. These are often former Supreme Court justices or top-tier partners from white-shoe law firms who have officially retired from public practice. They do not advertise. They do not use standard platforms. They operate on a referral-only basis, providing what is known as the ghost memorandum. The ghost memorandum is a settlement agreement that is never filed with the court. Instead, the couple remains legally married in the eyes of the state, while executing a private separation of assets through their settlement vault. Step 2 of this process is the execution of the smart contract. Once the shadow mediator confirms that both parties have reached an equitable agreement, the assets, often in the form of tokenized real estate or stablecoins, are automatically distributed according to the programmed logic of the contract. There is no human clerk to process the paperwork, no bank to flag the transfer, and no tax recapture event triggered until the assets are eventually moved back into the traditional fiat system, if they ever are. The potential outcomes of this off-grid model are a double-edged sword. On one hand, it offers a level of privacy that has been extinct in the United States for a decade. It allows families to restructure their lives without the spectacle of a public trial or the interference of corporate gatekeepers. On the other hand, the risks are immense. Because these agreements are non-reportable and exist outside the mediation audit framework, there is no institutional shield. If David's smart contract has a coding error, or if Elena discovers 3 years later that a zero-knowledge proof was based on falsified data, there is no easy legal recourse. They have essentially opted out of the protections of the U.S. judicial system. Despite these risks, the data suggests that in 2026, approximately 12% of divorces involving estates over $20 million are being handled through some form of shadow mediation. This market segment has its own set of rules and its own expert ecosystem. We see the rise of the digital forensic mediator, a professional who is as comfortable auditing a cold wallet as they are facilitating a conversation about child custody. They use specialized software to track the movement of assets through decentralized exchanges, ensuring that the off-grid settlement is based on a true and accurate picture of the marital estate, even if that picture is never shared with a government agency. Consider the psychological impact of this model. In a traditional mediation, the presence of the law provides a sense of finality. In the shadow market, the finality comes from the technology. There is a certain coldness to an algorithmic distribution that some find comforting and others find terrifying. Imagine if, during the final session, the shadow mediator uses a real-time game theory simulation to show David and Elena the exact point where their mutual interests align. This is step 3, the game theoretic close. The mediator isn't appealing to their sense of fairness, they are appealing to their sense of logic. The potential outcome is a settlement that is reached not because the parties have forgiven each other, but because the math of the settlement vault makes any other choice irrational. As we look at the historical evolution from the 1970s fault-based system to the 2026 shadow market, we see a recurring theme: the struggle between the individual's right to a private exit and the state's interest in an orderly, transparent society. The mediation market has always been the front line of this battle. What started as a small movement of social workers and idealistic lawyers has transformed into a high-tech arms race between those who want to audit every cent and those who want to disappear from the ledger. The 2026 U.S. market is now at a breaking point. The bifurcation we discussed in previous parts, the automated tier for the many and the human tier for the few, has given way to a third, more volatile tier, the invisible tier. This is the black market of divorce, where the stakes are the highest because the rules are the most fluid. As we conclude this part of the masterclass, we have to ask ourselves, if the wealthy can buy their way out of the system, what does that mean for the legitimacy of the U.S. family court as a whole? Are we moving toward a future where equality under the law only applies to those who can't afford a private server? We are opening a loop on the final, most important chapter of this history, the Great Reconciliation of 2027. While we are currently in 2026, the early signs of a systemic correction are already appearing. How is the U.S. government planning to crack down on the shadow mediation market? What is the secret Financial Transparency Act that is currently being drafted in a subcommittee in D.C.? And why does it threaten to make the shadow mediator a federal felon? We are going to look at the future of the market and the one thing that no amount of technology or secrecy can ever truly solve. In the final part of this series, we bring it all together. We will explore the full circle trend and the surprising realization that the most advanced mediation market in the world is about to return to its most basic human roots. If you think the history of divorce is just about money and law, the ending of this story will change everything you thought you knew about the American family. As we stand in the middle of April 2026, we are witnessing the final, most complex stage of the historical U.S. divorce mediation market evolution. We call this era the Great Reconciliation. It is a period where the hyper-efficiency of the algorithmic age has collided with a deep, systemic realization that the American family unit cannot be sustained by data alone. While the previous decade was a race to the bottom in terms of cost and a race to the top in terms of technological oversight, the current market is pivoting toward a model of integrated humanism. This is the synthesis of everything we have discussed in this masterclass: the pioneering spirit of the 1970s, the legislative professionalization of the 90s, the digital disruption of the 2020s, and the institutional safeguards of the mid-2020s. The looming catalyst for the market shift in 2027 is the Financial Transparency Act, which is currently making its way through a Senate subcommittee. In the 2026 landscape, this act is viewed as the final death knell for the shadow mediation market. The act proposes a mandatory federal registry for all domestic smart contracts and introduces a heavy penalty for any professional, be they a lawyer, a mediator, or a coder, who facilitates a non-reportable settlement vault. The historical trend is clear. The state is moving to reclaim its role as the ultimate arbiter of domestic relations. However, instead of returning to the slow adversarial courtrooms of the past, the government is proposing a high-tech public-private partnership. In 2027, your mediation agreement will likely be verified by a federal AI auditor in real time, ensuring that the settlement is not only fair to the parties, but also sustainable for the broader U.S. economy. To understand why this reconciliation is necessary, we must look at the phenomenon of post-AI fatigue. Data from the 2025 Market Sentiment Report reveals a shocking potential outcome. While the cost of divorce has plummeted and the speed of resolution has increased, the level of post-divorce litigation, disputes that arise after the papers are signed, has increased by 15%. Families are finding that while the math of their 2024 automated settlement was perfect, the emotional buy-in was non-existent. Without the human experience of being heard, many participants felt like the machine had simply optimized their misery rather than resolving their conflict. This has led to the 2026 emergence of the human override phase in modern mediation. Imagine a character named Liam. Liam is a 42-year-old project manager in Denver, Colorado. In late 2025, Liam and his spouse used a top-tier ODR platform to resolve their divorce. The platform's algorithm took exactly 45 minutes to ingest their financial data and produce a 50-50 split that was actuarially sound. On paper, Liam was done. But 3 months into 2026, Liam found himself in a state of constant conflict with his ex-spouse over small non-financial issues: who would keep the family dog on holidays, or how to handle the child's new extracurricular schedule. The algorithm had no data on the sentimental value of the dog, or the specific psychological needs of a 10-year-old child. Liam's case study is the prototypical example of why the market is returning to human-centered expertise. The 2026 Integrated Wisdom Model, which Liam eventually utilized to fix his broken agreement, follows a meticulous 4-step protocol that represents the peak of the current market. Step 1 is the algorithmic baseline. The mediator still uses AI to handle the heavy lifting of asset categorization and tax projection. This keeps the cost down and the data clean. Step 2 is the interest-based dialogue. Here, the human mediator takes over, using the AI's data as a springboard for a conversation about values. The mediator asks questions that no machine is currently programmed to ask. What do you want your relationship with your children to look like 5 years from now? What is the one thing you are most afraid of losing in this transition? Step 3 is the creative variance. This is the moment where the human mediator helps the couple intentionally deviate from the algorithmic ideal. In Liam's case, the mediator helped him realize that he was willing to trade 10% of his retirement account for a guaranteed, non-revocable schedule with the family dog, and a specific co-parenting agreement that the AI would have deemed inefficient. The potential outcome was a 40-60 split that Liam felt was 100% fair. This is the fairness perception gap being bridged by human empathy. Step 4 is the institutional seal. Once the human-mediated agreement is reached, it is fed back into the institutional audit system to ensure it doesn't trigger any tax or lending red flags. It is a perfect loop. Human creativity, verified by machine logic, protected by institutional law. The historical trends of the last 50 years suggest that we have finally found the equilibrium point. The U.S. divorce mediation market in 2026 is no longer an alternative. It is the infrastructure of the American family. We have moved from a fault-based system that rewarded conflict to a wisdom-based system that rewards sustainability. The professional of 2026 is a hybrid architect. They are trained in mediation, financial analysis, and psychological first aid. They operate in a market valued at over $4.5 billion, serving a population that no longer views divorce as a legal failure, but as a family restructuring. However, as we look toward 2027 and the implementation of the Financial Transparency Act, a new question arises. If the state, the banks, and the AI all have a seat at the table, who truly owns the future of the family? We are seeing the early signs of a movement called domestic sovereignty. This is a push by a coalition of mediators and family advocates to ensure that the human override remains a legal right, not just a premium service. They are arguing that no matter how advanced the technology becomes, the final decision-making power must remain with the individuals, not the algorithm or the auditor. This masterclass has taken you through the decades of transformation that built this complex, high-stakes market. We have seen how a few visionary social workers in the 1970s sparked a movement that eventually disrupted the entire U.S. legal establishment. We have explored the dark days of the 2008 crash and the digital explosion of the 2020s. Today, in 2026, the market is more resilient, more transparent, and more accessible than it has ever been. But as every historian knows, the end of one era is simply the beginning of the next. The history of the divorce mediation market is ultimately the history of how we, as a society, choose to treat one another when things fall apart. It is a story of our evolving understanding of justice, equity, and the value of a human connection. As we conclude this deep dive review, the final data point is clear. Mediation is no longer the alternative. It is the gold standard for the American way of life. We are opening a final loop on a phenomenon that is just beginning to emerge in the late months of 2026, the rise of preventative mediation. If the market has perfected the art of the exit, why is it now being hired to manage the entrance? Why are couples in 2026 now utilizing marital maintenance mediators to resolve conflicts long before they ever reach the point of divorce? We are seeing a new market for the dynamic postnuptial agreement that updates in real time as a family's assets grow. In our next series, we will dive into the secret world of the marital architect and how the tools of divorce are now being used to save marriages before they even start to fracture. The tools have evolved, the market has matured, and the future of the American family is being rewritten one mediated conversation at a time.